Hello, everyone, and welcome to today's book launch and discussion of the Colombian Peace Agreement, a multidisciplinary assessment. My name is Jennifer Wallace, and I'm with the Center for Human Rights and Restorative Justice at McMaster University, and I am your tech host for this event. So before we formally get started, I'm just going to briefly go over the features available to you in this webinar and the ways you can participate in today's discussion. This information will also be posted shortly in the chat for your reference. So closed captions are available by clicking the icon on your Zoom menu panel titled Closed Caption or Live Transcript. To access simultaneous Spanish translation of today's event, please click the Interpretation button on your menu panel, select Spanish from the list, then you are provided with the option to mute the original audio or leave the English audio at 20% volume. And thank you to Daniel for translating for us today. To submit your questions for the panelists throughout the event, please use the Q&A feature on your menu panel. There will be some time for discussion after each individual panel, and then we will also answer audience questions in a larger Q&A session toward the end of the event. And just a reminder, this event is being recorded and it is currently being live streamed to the Center for Human Rights and Restorative Justice YouTube page for our supporting partners. And with that, I will pass things over to Bonny Ibhawoh to formally introduce today's event and provide our land acknowledgement. Thank you.
Thank you very much, Jennifer. It's nice to see everyone again. I see quite a number of familiar faces. Nice to see everyone. My name is Bonny Ibhawoh, and I'm the director of the McMaster Center for Human Rights and Restorative Justice. And we are very, very delighted to be part of this book launch and panel discussion. As is the custom here in Canada, I would like to begin with a land acknowledgement. Although this event is happening virtually, we are all in some way rooted in land and space. So I would like to begin by acknowledging that McMaster University, where our center is housed, is situated on the traditional territory of the Haudenosaunee and the Anishinaabe nations, and within the lands protected by the Dish with One Spoon, One Pond agreement. It is an agreement amongst all allied nations to peaceably share and care for the resources around the Great Lakes. For those who may not be familiar with this Canadian tradition of land acknowledgements are a way of acknowledging the history and contributions of our Indigenous communities. The tradition of land acknowledgement has also lately been reinforced by the Canadian Truth and Reconciliation Commission, which was established to investigate the abuses suffered by Indigenous children and their families in the residential school system. Only a few weeks ago, the mass graves of 215 Indigenous children who died in the residential schools were discovered in the Kamloops Residential School in British Columbia. We honor their memory. The topic of historical injustice and truth and reconciliation is one that the book that we'll be discussing today also tackles. It is a topic that is common to those who work at the intersection of peace studies and transitional justice. The Colombian Peace Agreement, a multidisciplinary assessment, a book edited by Jorge Fabra, Andrés, Molina, Ochoa, and Nancy Doubleday, it's an important contribution to these larger debates about peace building, transitional justice, and dealing with the legacies of historical injustices. The book is the first systematic interdisciplinary examination of the peace agreement signed between the Colombian government and the Revolutionary Armed Forces of Colombia to end one of the world's most violent conflicts in the Western Hemisphere. It discusses the achievements, failures, and challenges of this innovative peace agreement and its implications for Colombia's future. Both Dr. Nancy Doubleday and Jorge Fabra, who are co-editors of this book, are affiliated with our center, and we are very pleased to be involved in the book launch, in this book launch, and what promises to be a very interesting and stimulating and enlightening discussion that will follow. The topic of this book also aligns very well with the mandate of our center, which is the multidisciplinary study of human rights, peace-building process around the world. So it is my particular pleasure to welcome you all to this virtual event, and hopefully looking forward to a very exciting discussion. Thank you. So I hand it back to Jennifer now.
So I believe we have a few more introductions from the editors. We'll pass it over to them now.
So, hello everybody, and before I begin, I would like to say hola, y los que estén escuchando en inglés, hay interpretación disponible en español, tienen que hundir abajo, y ahí está la posibilidad. Well, I continue in English now. So I am Jorge, I'm one of the co-editors. I am Colombian, currently living in Canada, and stated in the land acknowledgement I live in the lands governed by the Dish with One Spoon Agreement. And we're here to launch a book that studies the peace agreement signed in 2016 between the Colombian government and FARC, the Revolutionary Armed Forces of Colombia, in order to end one of the largest and most violent conflicts in the Western Hemisphere. So this peace agreement not only includes measures to end the violence and grant political participation to former combatants. The agreement also established measures to deal with the sources of conflict, including rural development, illicit drugs, and most importantly, created a comprehensive system to address the victims' rights for peace, justice, reparation, and non-repetition. This system includes, among others, the Special Jurisdiction for Peace, the Truth Commission, and several special units. In this year, there has been success. So a substantial part of FARC demobilized and remains in civil life as a political party. We have an institutional system in place and is achieving some tangible results. For instance, recent developments concerning false positives, extrajudicial execution by the Colombian army, among others. However, it faces numerous challenges, and including the implementation of many provisions, the protection of former combatants and social leaders. Why, for some people, priorities seem to have shifted at this moment. So we have COVID, we have social unrest, social protests in Colombia. Perhaps we might discuss them because FARC is no longer the center of the political life. So, and the peace agreement establishes the foundations that might help transform Colombia and inspire future peace processes in the world. So this is why we're here. So our book, and this book launch, aims to assess the achievements, failures, and challenges of these innovative peace agreements and the implications for Colombian futures and other peace agreements. We are fortunate of having among our contributors some of the leading experts in the field. We have judges of the Special Jurisdiction of Peace, representatives of civil society, and leading academics in peace studies, human rights, international law, international criminal law, transitional justice, political science, and philosophy. Our work is based on two premises. The first one is that peace is a form of transferable social knowledge, and it needs transformative social learnings. And we can learn each other in these in different peace experiences. And also, we believe as we believe in the McMaster Peace Studies Department that hope is a basic political emotion, and the hope for peace and transformation is something we should strive. So on my behalf, on behalf of my co-editors, I would like to thank first of all contributors for their support and patience. And many of you have important academic, official, and civil society positions and have the time to engage in this long process. I thank you all. I'm really pleased to see you here, a lot of you with us. I would like to thank also McMaster University Center for Human Rights and Restorative Justice, its director, Bonny, Ibhawoh. And I would like to thank also some partner institutions who are also helping in this launch, including the Justicia, the Colombian Commission of Jurists, the Center for the Study of Latin American Criminal Law from George August University University in Göttingen, Birkbeck College of University of London, the Woman and Gender in Global Perspective from the University of Illinois, the Center of Human Rights and Democracy from Georgia State University, and the Institute of Legal Research from Universidad Nacional Autónoma de México. And some of these institutions are also broadcasting this event in their websites. I also would like to thank especially to Danielle for providing translation and Jennifer for her hard work in the background. One final note is that one person listed in the program could not join us, is Congresswoman Juanita Gobertus, who was called to the Congress, and there is some work to be done there, so she will not join us. So Professors Molina and Doubleday have also some words.
Professor Doubleday, are you going to begin? Should I continue, or do you want to continue?
We go in order. Andrés, you're next. You're next.
Okay. So first, welcome again. I also want to remind you that because we are translating these presentations, we ask you to speak slow, so we are able, the translator is able to do his job. Anyway, I want to explain you're going to listen to very interesting conferences that will tell you a very important ideas about the Colombian peace process. But I want to first thank Jorge and Nancy for all their support and their wonderful job. And I want to begin by explaining like the lessons I have learned by editing this book. This is something that you won't find in the book. This is the lessons I have learned in the process that began with a crazy idea that Jorge and I had, and the incredible support that we received from Nancy. The first thing that I learned is that there are a lot of wonderful Colombian academics that are studying the Colombian peace process from a variety of disciplines and perspectives. And to know them and to know their job has been a very important inspiration for me. And we sometimes as Colombians don't realize and sometimes are not thankful to the quality of the job of our colleagues. The second lesson that I learned is that the Colombian peace process can be and must be studied from disciplines, from a variety of disciplines that sometimes are very different. I mean, we here have a professor of literature, we have historians, politicians, philosophers, lawyers, and this amount of this variety of disciplines allow us to understand the process in a better way. And the third lesson that I want to share is this one. When we were having the conference that actually inspired this book at McMaster University, I spoke about the right to the truth, and I was kind of convinced that if we associate the right to the truth to the idea of human dignity, we were having some kind of, I mean, it was a good way to justify it. And one of the members of the public asked me a question. Well, we in Canada, some members of the indigenous nations in Canada don't agree with you, wouldn't agree with you because they don't want a true commission to tell their story. So then I realized that the right to the truth has a totally different perspective I have never imagined. And I began to read actually more about it, and I get inspired to change my research. And that shows me why probably this book is important, because in the moment that we learn from other experiences, from the failures and success of other groups, we are more able to understand our own peace process and our own struggles for peace. Again, welcome to this conference. And again, thank you a lot for all the participants, and especially for my co-editors, who I am very happy to have met you in this wonderful trip to co-edit this book.
I really want to just speak very briefly. I want to acknowledge everyone who has been part of the process, and especially Andrés and Jorge. I am really the ultimate outsider. I defer to John Elster, who spoke briefly and formally at the beginning, but truly as a Canadian, I could be considered perhaps the outlier here. However, in understanding the process and in understanding the role that other nations play in internal affairs, I've come to the conclusion that we are all responsible for maintaining the peace. And that is the view that allows me to bring forward a small measure of perhaps apology on the behalf of some of the efforts made to interfere in matters in Colombia by outsiders. So I don't want to say more than that, except that every step any of us can take toward peace matters. And I subscribe very much to the philosophy of hope that Jorge spoke to. It is a powerful force, and we will make change. Thank you all for being here today. Thank you.
All right, so we will move now into panel 1, titled General Assessments of the Peace Agreement, and this will be chaired by Jorge Luis Fabra-Zamora. Oh, you're muted. Here we go.
So the core of the event has 3 panels, and each of them chaired by one of the 3 co-editors. And the key idea is to since this is a book launch, the key idea is that each of the book contributors presents the key contribution and findings, and then we have a small space for discussion, and when we expect to have an even larger at the end. So we, for the first panel, we have five guests. So first of all, Professor John Elster, which is the Robert K. Merton Professor of Social Science from Columbia University. Maria Paula Saffon, who is a researcher in the Institute of Legal Research of Universidad Nacional Autónoma de México. Gustavo Gallón and Juan Carlos Ospina from the Colombian Commission of Jurists, which is a Colombian NGO, and Professor Oscar Guardiola Rivera from Birkbeck College. Each of them contributed with different chapters of the book. And the strategy right now is that each of them is going to briefly summarize for us their main contributions, and then we're going to have some space for questions and discussions. So Professor Elster first. Unfortunately, it's muted.
Okay, so now I put the translation on Spanish. Is that working? Is it working? Okay. Well, I'm really the fifth wheel on this wagon. I don't quite belong here, because in an assessment of the peace agreement, it's strange that I should be participant, since my contribution was written in January 2014, 2 years before the peace agreement. So as I said, I don't really belong here. Sorry, I have to. Okay, fine. So as I said, I don't really belong here. But I'll say a few things about my brief chapter in this volume. And first, I have to explain how I got into this. The study of Colombia and the peace, civil war and the peace agreement. It started with an invitation by Antanas Mokus to spend some time with him and his team in Bogota, and I went there many times over the years between 2003 and 2014 to participate in and organize conferences on a variety of topics, mainly transitional justice and distributive justice. Then I had the extraordinary stroke of luck that 2 of my students at Columbia were from Colombia, and they were my teachers, Maria Paula, who is here, and Paula Kalmonovitz. So over the years, I learned a lot from them, and in particular, something very important, namely that my own specialty in the past, transitional justice, was not the only relevant concept of justice in this transition, because, as it were, transitional justice and distributive justice competed for scarce resources, in particular land. So with respect to allocating land to to the peasantry. There were the victims who had their land taken from them. There were collateral victims who had to flee because of the civil war. And simply, lastly, the landless, who didn't have any title or possession. So I think the lesson I learned from Pablo and Maria Paula was that unless transitional justice is accompanied by distributive justice, the post-transition situation will be unstable. That is, to the extent that, well, let me put it differently. A transition should not address the issues that looking at my notes here. Well, the transition should address both issues of transitional justice and of distributive justice. And so land reform should be the overarching principle. Now, that refers to victims. At the same time, one has to incorporate measures for dealing with wrongdoers. And in this respect, the Colombian process was unique in negotiated transitions because it was subject to a popular referendum and approval. And that was important because the negotiators at the table knew that they had to moderate their demands on both sides, both with respect to severity and with respect to leniency, because especially with respect to leniency, because if the punishment was too lenient, then the peace agreement might be rejected by the referendum. So the way I formulated the main dilemma in my notes from January 2014 was whether there existed a window of severity of punishment for essentially FARC members that was both would both satisfy the population and would be acceptable to the FARC leaders. So that at the time in January 2014, I wasn't sure whether there was such a window, and you have to tell me whether such a window does exist today. So transitional justice is an issue I worked on for many years, but that was not really what took place in Colombia, because Colombia did not experience a regime transition, but the negotiated end of a civil war. But nevertheless, there are some similarities between negotiated transitions to a new regime and negotiated transitions to end a civil war, especially that the autocratic regime has to accept, the leaders of the autocratic regime have to accept the conditions that are or transitions, so that they are not punished too severely, and similarly in transitions to peace in a civil war. I think the unique feature, which I've not seen in any other transition, either to peace or to democracy, was the referendum that sort of disciplined the parties and prevented them from making extravagant demands that could not be, in fact, accomplished.
So I'm sorry to interrupt you, Professor Elster. So we are supposed to have very brief interventions. So and we have more space for more discussion a bit later. So sorry about that. So and let's try to manage time. So Jennifer, let's move like the schedule a bit 10 minutes, and let's change a bit from the last panel. So next in our list is Professor María Paula Saffon from the Universidad Nacional Autónoma de México.
Hello, thank you for the invitation. I'm very happy to be here with my advisor, John Elster, who I admire very much. I also want to say that Sergio Jaramillo sends his greetings to everybody. He preferred not to be here because he was part of the process and so felt strange being part of the evaluation of the process. But he's very interested in the conference. Well, I'll start by saying, or I'll start and end by briefly summarizing my chapter. What I try to do in the chapter is to ask whether the peace agreement in Colombia was an opportunity for social transformation and whether that opportunity was lost or is being lost. I first argue that the peace agreement is very important. It's a very important achievement because it was really difficult to get to that moment of the agreement. There were multiple obstacles, the usual obstacles of peace agreements, of parties being very distant between each other, the difference between reaching peace and then building peace, but also peculiar obstacles in the Colombian case. And in particular, I focus on what I call, and other authors have called, an equilibrium of violence, whereby elites in the country profit from violence, or at least are not affected enough by violence such that they want to change it. And that equilibrium implies that elites at the local level benefit from the state being weak and from there being violence to control the distribution of wealth, to repress people who want to be incorporated in politics, and to rule through violence. And then elites at the center generally allow this to happen as long as they're not affected by the violence. So when there's no spillover of the violence, central elites are fine with violence taking place. And so really peace agreements are attempted when central elites get affected by violence being too severe. But this makes not only the reaching peace very hard, but also implementing peace, because the logic of violence, benefits many people. I also then talk about how rocky the implementation of the agreement was. Before that, I also identify that the agreement has two very important things to counter this difficult context. First, that it identified the conditions that were necessary, needed to be changed for the equilibrium of violence to be broken, and that is not usual in peace agreements, and that hadn't happened in Colombia before. And so many social, political, and economic reforms were thought of as mechanisms to break with the equilibrium of violence. The agreement also quite unusually and smartly thought about enforcement mechanisms, which is unusual in peace agreements as well. Still, the implementation of the agreement was rocky because of at least three factors on which I reflect. The first is the perennial deficit of legitimacy that derived from the plebiscite, which led both to a weak basis of support for the peace agreement and to the increase of the political standing of opponents to peace, which eventually led Duque to power. Second, this led to the predominance of a minimalist version of peace, whereby many elites started thinking that peace could just entail demobilization and punishment of armed actors, and particularly guerrilla members, but not the transformative issues of the peace agreement. And this is in fact the agenda that Duque and Uribistas in general are trying to promote. But as Professor Elster mentioned earlier, it's very difficult to separate the two things, right? And minimalist peace without transformation can bring about new waves of violence. And the third thing is that because the peace agreement did promise these social reforms that are so important, even though those reforms haven't been carried out to the full extent, Many people have organized, mobilized, and tried to participate politically to bring them about and to demand them. And so this is the current force of change in Colombia, which is very well illustrated by the current protests, about which we can talk later on. The problem with these demands is that, of course, because the violent equilibrium still exists in Colombia, many people are being targeted for mobilizing for peace. But it seems to be the case that people have had enough of the lack of transformation, and they're willing to stay on the streets until distributive justice in some form takes place in Colombia. And so I will end there. Thank you.
So thank you so much. Let's try to be a bit more brief. So the next is Gustavo Gallón, who is the director of the Colombian Commission of Jurists. It's an important NGO.
Hello, everybody. Thank you very much. Let me thank and congratulate Jorge Luis Fabra-Zamora, Nancy Doubleday, and Andrés Molina Ochoa for this book and for this event. And let me also to say hello to Professor Bonny, Ibhawoh, and my colleagues at this panel, Professors John Elster, Maria Paula Saffon, and Oscar Guardiola, and my colleague Juan Ospina, who is also co-author of the article we read together for the book. Let me raise three main ideas. First, the peace agreement is a very well achievement for many reasons, especially two, many others, but especially two. First, it creates a comprehensive system of truth, justice, compensation, and non-repetition, as Professor Fabra-Zamora said, according to the most important developments of international human rights law and international humanitarian law, and based on three strong institutions established by the agreement: the Jurisdiction for Peace, the Truth Commission, and the Unit for Search of Disappeared People. And second reason for this well achievement is that the agreement identifies a key issue being at the center of the political violence in Colombia, as Professor Elster has also said, which is the concentration of land based on many illegal practices exercised during centuries, including usurpation, killings, and forced displacement, and establishes a program of rural reform according to existing but not implemented legislation oriented to, first, measures for improvement of land access and use; second, programs of development with a territorial approach; and third, an ambitious plan to improve access of the rural population to health, education, housing, work, and income, as well as supports such as infrastructure, economic stimulus, subsidies, and work assistance in areas historically affected by the conflict. A second point I would raise is that the implementation of the agreement has been severely limited by the results of the plebiscite, of the referendum, and the opposition of a significant sector of Colombian society, instigated especially, but not only, by the political party chaired by former President Uribe. The current government belongs to that opposition movement to the peace agreement and has not hidden its disaffection, particularly to the Jurisdiction for Peace and to the Truth Commission, and to the implementation of rural reform. The third and last point is that the agreement is producing some positive effects and is still alive despite the reluctance to its existence, thanks to several important factors, such as the activity of important institutions promoting and protecting its implementation, like the comprehensive system of truth, justice, compensation, and non-repetition, the Constitutional Court, and others. The monitoring mechanisms established by the agreement itself, the reports by Kroc Institute, and by the two Colombian institutes, CINEP and CERAC. The performance of the mandate of the United Nations Mission and of the United Nations High Commissioner for Human Rights, and the periodic review of the process by the United Nations Security Council. The presence of important members of the international community, like the European Union and some particular countries. The scrupulous respect observed by former FARC members and the new Comunes Party committed with the agreement. The activity in favor of the agreement held by prominent sectors of civil society, like political forces organized around Defendamos la Paz, social movements, human rights platforms. Let me conclude by saying that it is vital that these forces, as Professor Doubleday also said, these forces, especially the international community, can continue expressing their support to the agreement at their strong request for its proper implementation. Thank you very much.
Yeah, thank you so much, Dr. Gallón, and let's have also Professor Oscar Guardiola Rivera from Birkbeck College.
Thanks very much indeed. Let me just begin by saying that the chapter with which I've contributed to this anthology emerged from my experiences as part of a sort of Channel B of the negotiations that took part very briefly in San Sebastian in the Basque country. It studies the Colombian peace process as an instance of aesthetic justice. Rather than adding another concept of justice to punitive or restorative and redistributive ones, that notion focuses on the transformations that must occur at the level of emotions and affects.
Professor Guardiola, sorry for interrupting you. It's a bit low. I think a lot of people are having trouble hearing you.
Sorry about that. Is that better? Is that any better? Good. So just very briefly, I was saying that the chapter emerges from the experiences I've had as part of the sort of Channel B of the negotiations that took place very briefly in the Basque country. And it studies the Colombian process as an instance of aesthetic justice. So rather than adding another concept of justice to punitive or restorative and redistributive ones, that notion focuses on the transformations that must occur at the level of emotions and affects for redistributive negotiations to take place and succeed. Now, it has been said that there are two typical obstacles in mediation and negotiation: indeterminacy and irrationality. I'd like to add a third. Anthropologists call it the management of knowing what not to know, or public secrecy. Now, everyone knows what happens in Colombia, who disappears and kills, but some people prefer to feign ignorance and convince themselves that such kind of violence is visited only or justifiably upon a set of seemingly disposable lives: communists, natives, Afro-Colombians, dissenters, the poor, and that they themselves do not fit in such categories. If we learned anything from the Colombian peace process, it would be two things. First, that there are people who live a fiction, the fantasy of a world without others, which they take for the real non-fictional world. Second, that most Colombians who have now taken to the streets or sympathize with the kids who do so have used aesthetic means to visualize a fiction, a vision of a better world that sharply contrasts with the one they live in, adjudged inadequate, and set out to work in order to turn that fiction into non-fiction. That's when art that happens in demonstrations becomes normative and gives demonstrators a sense of orientation, of the possibility of progress as an imperative. That knowledge cannot be managed by the state, no matter how many lies and disinformation they spread. It is no longer uncertain, and it is self-creative of different forms of rationality that cannot be easily subjected to calculus and governance by numbers. The notion of aesthetic justice, which I focus on this chapter, seeks to account for those radical mutations which happen to people that rehearse awareness in negotiations and demonstrations. Thanks very much.
Jorge, you're muted.
Sorry, so thank you so much, Professor Guardiola Rivera, and all. I think in the interest of time and in the interest that everybody has a small say, we'll stop the Q&A. I see that we have some questions for each of you and I will address all the questions at the end. I think that will be the best way to start here. And first, we will give the opportunity for panelists to ask questions to each other if there are any, and then questions for the public. So the best strategy right now is to move to the second panel in the interest of time. So Professor Doubleday, she will chair the second one. Thank you so much.
Thank you to all. Thank you, Jorge. For this panel, our focus is transitional justice, and we are going to hear from four of the speakers. The fifth is not able to join us. And so first, I invite Daniel Rojas Betancourt, who is Justice and President of the Appeals Section of the Special Jurisdiction for Peace. Please, you have the floor, and we'll look forward to hearing from you for some 4 or 5 minutes. Thank you.
Thank you. Thank you, Professor Nancy. Thank you, everybody. Thank you, Jorge, for the invitation again. In the article, I highlight 3 of the SJP most important legal challenges. First, the relationship between transitional and permanent judicial institutions. Second, the clarification of open texture provisions. And third, the consolidation of the corpus juris of human rights law and international humanitarian law. About the first challenge, as is known, the Colombian transitional justice model relies on the July's work carried out by the ordinary justice system. This is what is done by the prosecutor office and by criminal judges. This requires coordination that today has not been without difficulties. The most notorious of them, which is not in the article because it is recent, is that both the prosecutor office and the Supreme Court of Justice in Colombia itself considered that they had competence to fix some aspect of related of the internal armed conflict, despite that the norms that created the SJP give it exclusive competence to the subject. Fortunately, the Constitutional Court has already said that when resolving several conflicts of jurisdiction, that everything related to the internal armed conflict that occurred before December 2016, that's it, before the signing of the peace agreement with the FARC guerrillas, is within the competence exclusive and excluding of the SJP. In any case, coordination efforts must continue between the work we do in the SJP and what the ordinary judges have done on cases related to the internal armed conflict. This coordination must also be done with the work carried out by international judges such as the Inter-American Court of Human Rights and with the work carried out by the International Criminal Court. On the second challenge, as the SJP must operate with new regulations, these first 3 years of operation of the SJP have been important in clarifying ambiguous normative tests and clarifying certain legal procedures. Remember that the SJP judges both guerrillas and members of the public or security forces and third parties who had committed serious crimes within the framework in the internal armed conflict in Colombia. And each of these groups of people have different trial procedures that also depends on whether they provide truth or not, and whether or not they contribute to repairing the damage causes to the victims. And finally, an important legal challenge in the SJP is to contribute to the consolidation of what is usually called the corpus juris of human rights law and international humanitarian law. This challenge integrates the two previous ones, as the SJP must apply not only domestic law norms, but also international legal norms, including those of the Rome Statute that create the International Criminal Court. The normative analysis made by the SJP must include the interpretation that authorizes judges such as the Inter-American Court of Human Rights or the ICC. But these international judges should also incorporate the normative reflections that the SJP is making this moment, taking into account the specificities of the cases. This kind of jurisprudential dialogue should be symmetrical and thus should contribute to the formation of a robust universal doctrine in defense of the human rights in general and the rights of victims in particular. In short, it must contribute to the increasing strengthening of the corpus juris of human rights and international humanitarian law. Thank you.
Thank you so much, Professor Danilo. Dr. Danilo, I believe now. So thank you so much. And we are grateful for your words. I'm sure there'll be much discussion. I would like to turn now to Professor Colleen Murphy, who is an authoritative scholarly voice and has always provided us with much discussion. So please, Professor Murphy.
Thank you. So first, thank you to Jorge and Andrés and Nancy for the original invitation to be part of the conference from 2017 and provide me with an opportunity to learn more about Colombia. So I feel I've come out of the conversations both in the conference and since then more as a student than as a contributor to understanding the dynamics of conflict and peace there. So my contribution takes as its starting point the fact of deep disagreement as to whether justice is achieved with alternate measures such as amnesty or a truth commission or the special jurisdiction for peace, and the political divisions that moral disagreement can generate. And I think we see this play out very clearly, or this played out very clearly in the plebiscite of 2016 and in the explanations that were offered for why citizens had voted in the way they had, and the criticisms about the morality of the agreement itself, and the defenses of the morality of the agreement. So my piece looks at, so what are the standards of justice to use when evaluating how agreements like the agreement in Colombia lays out processes and strategies for dealing with wrongdoing in transitional circumstances. And so to answer this question, I draw on some of my work that first tries to articulate what I call the circumstances of justice, characterizing transitional contexts like Colombia, which include features such as the normalization of wrongdoing, deep political fragility, and structural inequality, and argue that the point of justice, what the measure of justice is not giving perpetrators what they deserve, as retributive justice, for example, lays out. It's rather trying to transform a community, to alter how citizens interact with one another and with officials, and do so in a manner that treats victims and perpetrators who are subjects and participants of transitional justice processes fairly. So from that perspective, when answering the question that I was offered, what are the successes and failures of the Colombian peace process? I think the Colombian Peace Agreement itself and the framework it lays out is a resounding success from the perspective of justice in providing a comprehensive roadmap for both doing justice to victims and meting out justice to perpetrators through the Special Jurisdiction for Peace, through the Truth Commission, the Unit for the Disappeared, and also laying out measures for tackling structural inequality, which is critical for transformation through, for example, commitments to rural reform. But my chapter ends where many of the conversations today begin, which is whether the justice that's envisioned is actually achieved depends on ongoing political will and a commitment to actually realizing the framework that's outlined in that agreement. And I think that the last few years have demonstrated the unevenness of the political will, its presence in some areas and absence in others. And so what Colombia teaches the world, or other conflicts of the world, how it speaks to, this is the final point, is both the possibility of having a comprehensive vision for dealing with conflict, both in terms of the consequences of conflict, in terms of victims and perpetrators and rights violations, as well as trying to tackle the root causes of conflict, and also points to the fundamental fragility of realizing any comprehensive vision that an ambitious peace agreement like the one in Colombia lays out. So I'll stop there.
Thank you so much. Thank you so much, Colleen. Very much appreciate your words. We turn now to Professor Kai Ambos, who is an authoritative expert who speaks about comparative law in the criminal court systems. Importantly, is a special advisor to the Court of Special Jurisdiction. He's a friend of the court. And so please, Professor Ambos, would you take the floor?
Yes, good evening from Germany. We have now almost 8 o'clock. It's very hot here. That's why I'm a little bit without corbata, you know, and a bit easygoing. Thanks a lot to everybody. Thanks a lot to the editors. I know that was a very hard work for you to bring all these authors together and then edit the papers and produce a book. We all suffer from this as academics, you know, bringing together people and writing papers and then editing them and sending it back and getting it back and whatever. So that's a great book, and certainly that would be my first point. This Colombian issue is in the English-speaking world not really addressed as it should be. I mean, we still have very little literature, limited literature, and of course most literature is in Spanish. We have amazingly important literature in Spanish, but the book is a very important contribution also in this sense that it closes a gap in a way. I mean, you know, we have another important book by published by Cambridge University Press by 2 negotiators. So there are still books coming, but especially in English, I think it's very important. And also I think that we should not underestimate the role of academia here, and especially the Colombian academia. I think Nancy made this point. Okay, we shouldn't intervene, perhaps. That's, of course, we shouldn't, but we should maybe help the Colombian academics, our friends. You know, we have, for example, the German Colombian Institute for Peace in Bogota, and the Canadians are very active, and so on. So we really have to, with the universities, give also civil society a voice. And I think this constituency of the academia is very important in this kind of process, because, you know, within an institution, be it the HAP, the Special Jurisdiction of Peace, or being a politician, you are always inhibited to be very frank, you know, to be, you know, you have your different interests. And while the academics, especially in the US, in Canada, in Germany, in France, we are very free to speak out. And I think our role is very important to contribute to this and to perhaps give the greater picture. Well, I was asked to say something on the chapter. I must say I'm a bit hesitant because it's a bit boring, because the book is out and people can read the chapter. But since you are the boss here, Nancy and the other editors, I will, with your, I will of course defer to this request, but be very short, because the chapter is very basic. It's a very legalistic chapter. Basically, the point is, if the Colombian amnesty law, the famous Ley 1820, is compatible with international law. And that's important in the sense that a point Professor Elster made, in a way, then we come to the criminal law component of the peace process. You know, I mean, we have criminal law here. We can sanction people. We can sanction them until 20 years if they come to the HEP. And on the other hand, we give them amnesties. And then the question is, where are the limits of these amnesties? And you can imagine that this was a hard point in the negotiations. And it was already mentioned by Gustavo, Gallón, Uribe and Duque, of course, the right-wing parties in Colombia. I remember very well discussions in Bogota with before in the other government when it was said by these same people, well, we should think of the International Criminal Court, we should be careful, we must not give an amnesty. When the law 975 for the paramilitary groups under the Uribe government was made, and the arguments then have been turned around during the peace process under Santos, the peace negotiations. And so it seemed that the arguments are not the same, depending on from which perspective you look at them. But I think international law is quite objective. I mean, we have clear, more or less clear rules. We have, of course, on the basis of especially the case law of the Inter-American Court of Human Rights, a duty to prosecute, since the famous Velázquez-Rodriguez case, Honduras, in the 90s of last century, duty to prosecute, to investigate serious human rights violations. And of course, many of these crimes we are dealing here with these acts are serious human rights violations. And then, of course, we have this Rome Statute of the International Criminal Court, which is binding for Colombia and which clearly imposes on a state party to prosecute genocide, crimes against humanity, and war crimes, and the crime of aggression, not relevant in this context. But so the question, the clear situation is that a state, if it wants to abide by international law, and Colombia always wanted to be faithful to international law. Colombia has always been in the history of the peace process with M19, last century, EPL with all groups have always wanted to be faithful to international law. You know, I mean, Colombia is not a persistent objector as other states, for example, in our continent in Europe. I don't want to name them now. It always wanted to abide, and therefore for Colombia it was always important that this amnesty law should comply with international law. And I basically analyze the framework, and my conclusion is that the amnesty law is even going beyond international law, because it, on the basis of the crimes, the ratione materiae jurisdiction of the HEP, it includes crimes which are not under an obligation to prosecute, which going beyond the Rome Statute, in fact, you know. For example, sexual violence as a group of crimes, you know, it's not limited to the international crimes. And in this sense, the amnesty law is certainly in line with international law. But that's just about the chapter. But let me just finish with three more ideas or food for thought, perhaps, for our discussion, for congratulating McMaster University for taking this up and this important initiative. We always know Canada is such a great country, and we always get these great initiatives from Canada. Maybe you can think about it and continue this process and really discuss about the challenges, los desafíos, no, of the HEP and of the process. And there are three points which I want to highlight, and I would use three topics or catchwords which may describe these challenges. The one is the word implementation, implementación. It's obvious that, and Maria Paula made this point. I mean, if we talk about implementation, that's a fracaso. I mean, that has not been implemented. That's the truth of the matter. And if we go further, that's my second point. If we talk about transformation as a kind of new, kind of more idealist transitional justice goal, less so. I mean, we are in a situation where we have social protests in Colombia right now. We have people killed. We have líderes sociales asesinados, no, killed all over the country. We have here in my country, where I was involved, many Colombian refugees trying to get asylum coming to our administrative courts. I imagine the same will be in Canada. You may have many refugees from Colombia. They are all victims of the violence in Colombia, which has not stopped at all, which may have even be increased. So the third issue is security. I mean, if you are negotiating with anybody in the world, you have to give in something. And what the FARC wanted, I mean, I'm totally independent. I'm not belonging to one of these groups, but of course, security is a basic issue. If you cannot guarantee the security of one party negotiate at the negotiating table, if people are afraid that they will be killed, what happened all the time, as we know in the Colombian history. I mean, you think of the Unión Patriótica, 20,000 dead, and you think of the EPL, you think of all processes in Colombia, you always had no security. And that's the same situation now. I mean, it's not just for the FARC, it's for the social movements. And so we really have to tackle this, and we have to look at the implementation much more on the black letter law. Gustavo Gallón made this very nice point. I mean, he knows much better than all of us what that means, security in this country. But he just told us what is in the agreement. That's nice. That looks very nice. The paper is nicely written. That's a great agreement. I mean, it's 300 pages. Who read this agreement? I wonder all the time. It's a great agreement. We have so many laws, so many degrees, and it's all great. I mean, as always, the Colombian legislation is always great. But what is the reality? I mean, what is on the ground happening? And we are in a situation, even in Europe. I mean, it's not a big community of refugees. We have from Syria, we have from African countries much more, but we still have Colombian refugees coming, and they are political refugees. They get asylum in Germany because there is no security. They move from the coast to Bogota, to Medellin, to Cali, and there is no security, and the Colombian state does not offer security. And if we ask the Colombian state, as for example, administrative tribunals, can you tell us what do you do for these people? There are specific institutions in Colombia responsible for this. You do not get an answer, because if someone is an enemy of an important person in Colombia, there is no chance to survive. And so I think we really have to look beyond the law. We have to look at the reality, and that may be an important task also for universities like McMaster, other universities, to take this on and to really critically accompany this process. Thank you very much. Muchas gracias.
Muchas gracias, Professor Ambros. And now I think to lead us forward in response in part to the challenge you've presented us, we have Professor Jennifer McCoy, who is speaking about processes of change, and so transformation from below, which I think is a very powerful contribution. And I hope you will enjoy speaking to us, Jennifer, and I hope that we will have an opportunity to debate with you afterwards as well. Thank you.
Thank you. Thank you so much for being here. My chapter was done with my two colleagues, Ryan Carlin and Jelena Subotic, and we benefited from interviewing during fieldwork in Colombia in 2014, 15, and 16, interviewing actually many of the contributors to this volume, including Sergio Jaramillo, Juanita Gerbutz, Gustavo Gallón, Rodrigo Upinami and his colleague Nelson Sanchez. So we really benefited from that. Our chapter is looking at the impact of international human rights norms on peace negotiations in a democracy. And we make two basic points in our analysis. One is that international norm setting is usually done by who are considered the norm makers, usually developed countries in the North and the West. And the Global South is usually seen as norm takers, but following the literature and the evolution of the literature on how international norms are changed, evolved, adapted, modified, implemented, drawing from Amitav Acharya, we look at norm localization and change and how the Colombian negotiators actually tried to be norm makers as well, particularly in looking at alternative sentencing and filling in a gap in the definition of effective sentencing in the ICC and extending transitional justice to other actors. And we argue that within a democracy, actors negotiating a peace agreement have to act very differently from what we have looked at before in peace agreements, transitional justice coming out of civil wars or military authoritarian regimes. So I want to just share my screen for a minute to look at this one diagram, the way we conceptualized this, which is that the negotiators had to deal with international constituents, the ICC, the Inter-American Court, Human Rights Court, the United States, because they were going to extradite FARC guerrillas, and international NGOs, human rights NGOs. And then the domestic constituents, because Colombia was a thriving democracy, of course, with strong constitutional court, with very strong NGOs, organized civil society, peace groups, human rights groups, victims groups, a Congress that was going to need to approve the agreement and the implementing legislation, as well as public opinion, because it was envisioned a referendum. So this led to sort of two win sets for the negotiators, where the FARC's constituents, domestic constituents, basically wanted no jail, but yes, political participation. And the Colombian government was dealing with a public and with domestic actors who wanted justice, who wanted reparations for victims, but were generally, public opinion was not in favor of political participation. So we kind of analyzed that and look at the ratification needs of the negotiators in dealing with this. So what might be some lessons for others coming out of this agreement? I think there are many, but from our interviews and observations, we saw that Colombian negotiators seemed to assume that the international actors who could serve as saboteurs to this process, the United States by extraditing the guerrillas in the middle of it, the International Criminal Court by deciding to open investigations. The negotiators seem to assume, the negotiators on both sides, that the internationals would go along in the name of peace with their adapting of the norm and development of particularly alternative sentencing guidelines. And they appealed to the messages of peace over justice. So far it's been accepted, and I think, questions to be raised, and love other panelists' views of whether this strengthens or will it weaken ICC legitimacy, for example. How long will this be able to go, and will it serve as a good model for other countries to follow the norms? I know that Venezuela, I work on Venezuela a lot. Venezuelans are looking at the Colombian Peace Agreement as well as particularly transitional justice. And there is similar public skepticism about generally negotiating with what the public, the opposition in this case, considers criminals. So skepticism about this and future political participation. So I think there are good lessons to be learned from the Colombian process too, about not only the need for that, but how to engender trust among the public, how important that is in order to get support for transitional justice mechanisms, such as we see in the very important innovations that the Colombians carried through. Thank you.
Thank you so very much, Professor McCoy. Thank you. Very helpful remarks. I'm going to turn the chair over to my colleague, Andrés Molina. Professor Molina, please, would you initiate our third panel, please? Thank you.
Okay. I'm having having some problems with my, okay, good. So in this panel, we're going to speak about some components of the peace agreement. And I would want to invite Yuri Alexander Romaña, who is a lawyer at the Special Jurisdiction for Peace, to begin with his presentation.
Thank you, Andrés, and thank you to everybody who is participating here. I want to begin by acknowledging the hard work of McMaster University and the editors to put together this book, and also for the invitation to participate in the drafting of it. Our chapter, the participation of the rights of Colombians in the peace agreement and the mechanism of implementation, is the result of a teamwork with Justice Xiomara Balanta, who cannot participate today in this event because she has other commitments related to her role as a justice at the Special Jurisdiction for Peace, but it is an honor for me to be participating. With respect to our chapter, there are some points I would like to highlight. One is that we wanted to share a little bit of the history of the presence of Black people in Colombia, and to show or to share the situation of disadvantage that we have faced for centuries, and how the armed conflict had exacerbated those circumstances. And you can see that in the fact that one out of 4 Black people in Colombia is a victim of the armed conflict. Around 25% of the Black population is victim of the armed conflict in Colombia. And that's relevant because the participation of the Black population in the implementation of the peace process and their engagement with the different mechanisms established under the peace process is key for the success of the peace process. And that's something we wanted to highlight here. And we started or the emphasis of our chapter was chapter 5 of the peace agreement. Because it is the chapter that establishes the comprehensive, the creation of the comprehensive peace the comprehensive system for truth, reparation, and guarantees of no repetition. And in that sense, we highlighted how Afro-Colombians participate, for example, in the work of the Special Jurisdiction for Peace, in the work of the Truth Commission, and in the work of the Special Unit for search of people deemed as missing. And we highlighted 3 elements we pointed out to 3 elements that we consider relevant of the participation of Black people in the peace process, and especially in the comprehensive system. One is the roles as decision makers in these institutions. For example, in the Special Jurisdiction for Peace, we find that there are 4 justices who belong to Black communities. One of the justices is Xiomara Balanta, with whom I co-authored this chapter. We also find that another means of participation is the presentation of reports. We have seen that many Black organizations, or civil society organizations, have submitted to the Special Jurisdiction for Peace different reports by which they want to share how the armed conflict have impacted them and their territories. And that's something very relevant. When it comes to the Truth Commission, there is now the chairperson of the Truth Commission is not a Black person, but we have the hope that in the future we may have a Black person leading the the Special Unit for Search of People Deemed Disappear. Is the person who leads that institution is not a Black person, but we hope that in the future we may have a Black person leading that institution. But the Special Unit for Search of People Deemed as Disappear has a commitment to engaging with Black community with carrying out activities on their territories to establish the whereabouts of people deemed as disappeared. And that's relevant because what they are trying to do is trying to make sure the activities they carry out in those territories respect the tradition and the worldview of this community. And also engaging with this community allow the special unit to be able to be more effective in how they carry out their work, and to really be able to go to the places where missing people or disappeared people might be. Because these communities really know their territory, and they can be guides in those activities. Now, when it comes to the Truth Commission, there is a member of the Truth Commission who belongs to Black communities, Leiner currently. Before we had a woman, Ms. Salazar, who passed away last year due to COVID issues, and now we have Leiner Palacio, who is replacing her, and both have committed to make sure that in the report, or the final report by the Truth Commission, there is a component that addresses how the armed conflict had impacted Black communities and how it had affected them in their ways of life, economically, socially, and that's something that we really need to have in this country to document, to be able to document what happened to Black people. And Black people play an important role by telling their story too. And how are they doing it? They are also submitting reports to the Truth Commission, for the Truth Commission to hear from them what they see is the truth about what really happened in their territory, what really happened to them. An aspect which is very relevant, or is transversal to the peace process, is the transversal application or the application and interpretation of the ethnically differentiated approach, which is basically a legal concept developed in Colombia, which seeks to guarantee that in the adoption and implementation of policies, government institutions take into account the impact that those policies or legislation might have on the territory of Black communities and indigenous communities. And using that principle as a guidance, the special jurisdiction has, for example, has developed a protocol to interact with these communities, to make sure the special jurisdiction, when we go to the territories of these communities, we are able to have the authorization from them. We can also hear from them how they want us to go to their territories and be able to carry out our work in a very respectful way. This peace agreement, I think, historic because unlike other peace agreements, it acknowledges the importance of having into consideration the implementation of this ethnically differentiated approach. And that can guarantee that moving forward, the implementation of the peace agreement and the work of the different components are really, really, really in line with the interests of these communities. Is this easy? No, it's not easy. It's challenging because there are many challenges these communities are facing right now. Security challenges, as some of the co-panelists were sharing. In Black communities, that situation is exacerbated because because of the natural resources present in these territories, the history of violence that they have faced that continue to take place today, because many places that were left by the FARC with the demobilization are being occupied now by other armed actors, and that plays a role. You see that there have been killings in those territories of social leaders who are pushing hard for the implementation of the peace agreement. So there are challenges, and the HEP and the Special Jurisdiction for Peace and the other mechanisms are committed to working with those communities, and I think that's a good sign, that's a good step in the right direction. But more needs to be done, not only from the institutions that are a part of the comprehensive system for the of Chapter 5 of the peace agreement, but the whole government institution as a whole, to make sure that this community and their leaders are protected and they can participate freely and they can be heard in this context of in the implementation of the peace agreement. I will leave it there, and if there are further questions in the next stage of this panel, I will be happy to answer them. Thank you.
Thank you, Professor Dr. Romagna Rivas, and now I give the word to Dr. Diaz Rios, who is a professor at the Ontario Institute for Studies in Education at the University of Toronto.
Thank you, Andrés, and thank you everybody for attending this book launch, and a special thanks to Jorge, Andrés, and Nancy for their hard work putting this together, the conference first, the book later, and now this nice book launch. So they ask us authors to share some of the highlights or key ideas in our chapters. And my chapter focuses on education policy in the context of the Peace Agreement, and it particularly analyzes the political challenges of shifting education from a cause to a solution of the Colombian conflict. Although proving that education is a cause of the Colombian conflict is out of the scope of my chapter, it is not impossible to think that education inequality may have contributed to this violence that we experienced. So consider, for example, that only 55 out of every 100 students completing primary education in Colombia actually finish secondary education. And also we know that access and quality of education is highly unequal between rural and urban areas. And the Peace Agreement acknowledges and addresses these inequalities in a way that is also consistent with what we have learned from education in post-conflict societies. And that is actually a success of the agreement. The agreement doesn't produce a particular plan, but it set the principles for what later would be called the Special Plan for Rural Education that kind of put together a route to transform rural education in the country. Now, my chapter argues that this special plan faces similar problems of previous attempts to improve rural education in the country, such as rural development concentrations, Escuela Nueva, and the Education Rural Project. Although these initiatives demonstrated their success at the beginning, Colombian political elites downplayed them because these programs compromised either existing political gains or did not bring substantial political benefits to them. By the same token, the Special Plan for Rural Education is not sufficiently attractive for these political elites. So we know that the government elected in 2018 was one of the strongest opponents of the peace agreement, and consequently, it has diverted attention from the associated initiatives, including this plan. And this government has not offered either incentives for subnational jurisdictions to pay more attention to rural education, which has been historically low. Also, this special plan has not secured funding. So by contrast to previous attempts analyzed in my chapter, the Colombian Finance Ministry did not authorize international loan requests for the post-conflict educational plan. Even before the pandemic, which is not included in my chapter, the special plan already needed to compete with multiple demands in and outside the education sector. Now, with the national strike, rural education is not even in the agenda, as it doesn't have sufficient or influential constituents, unlike, for instance, higher education, which is receiving all the attention and regardless is barely getting some additional resources. Even the education ministry is not really implementing the special plan, and instead is using its multiple existing programs to focalize conflict-affected rural municipalities without really paying attention to the principles established in the peace agreement or the recommendations or lessons that we have learned from education in post-conflict societies. So that could be kind of the failure part, which is consistent with how other contributors have mentioned, the problem of implementation. And in this way, it is very likely that education in Colombia continues to be, or continues contributing more like a cause for future conflicts rather than a solution for a durable peace. And I will leave it like that.
Thank you a lot, Claudia. I now want to invite Dr. Uprimi and Dr. Guisa Gomez. And well, everybody knows Dr. Primi, but anyway, he's a professor, he's the director of the Justicia, one of the most important Colombian NGOs, and Diana is a PhD candidate at Notre Dame University, and also it's a member of the Justicia.
Thank you very much. A warm welcome to everyone. We decided with Diana that she's going to present the chapter, and maybe afterwards I will comment on some questions. Diana, you have the floor.
Thank you, Rodrigo. So Rodrigo and I are grateful to Jorge, Andrés, and Nancy for having invited us to collaborate to this volume. And our chapter is centered on the interactions amongst constitution making, legitimacy, and peace building. And we tackle some theoretical questions by diving into the Colombian peace process. Enshrining peace commitments into constitutions and submitting peace agreements to popular endorsement have become crucial. And we can even say that mandatory means to lessen political violence. Post-conflict constitutions and direct citizen involvement are meant to build a broad-based participatory political system and transform the initial peace deal into long-lasting normative commitments. And during peace processes, there are some theoretical questions that are appealing to us regarding constitution makings. In such settings, the framers are bound to a peace agreement that was reached in a process where the framers were left aside. Indeed, we can say that peace processes are inherently elite scenarios in which only the warring parties are writing down commitments, even if the peace table is opened up to hear certain social and political groups' concerns, such as victims. Hence, the democratic capacity of the people is reduced by externally imposed constraints in peace conflict constitution making. And we tackle these concerns and this puzzle by diving into the Colombian case. Rather than seeking to frame a new constitution, the 2016 Peace Accord adopts an original constitution drafting design that comprises both representative democratic mechanisms, particularly fast-track authority to approve constitutional amendments, but also direct democratic measures, namely a plebiscite that was held on October 2nd, 2016. In this chapter, Rodrigo and I merely argue that initially constitution building and popular endorsement were aimed at neutralizing recalcitrant elites that opposed a negotiated settlement in Colombia. However, that innovative design wasn't accompanied by building a wide, strong pro-peace coalition in advance. So after the popular rejection of the peace accord, and since constitution drafting hinged upon popular endorsement, peace implementation has seemingly thwarted a transformative understanding of peace. And on this point, we agree with Maria Paula Saffon and her main argument in her chapter. So instead of isolating apparently minor outside spoilers, direct citizen involvement might have broadened elite divisions by reinvigorating opponents who had remained powerful enough to mobilize voters against the peace agreement and the peace process overall, and ultimately convinced hesitant supporters to become radical opponents. So once empowered, those minor factions have threatened to breach the peace agreement by radicalizing politics around the accord and leveraging influence with Congress members and other state officials to prevent peace commitments from being fulfilled. Finally, we close our chapter by laying out a set of ideal scenarios to theoretically capture how legitimacy, constitution making, and peace building have interacted in the Colombian case, and how this case relates to other significant cases that have been studied broadly in the literature. I will leave it here. Thank you.
Thank you a lot, Dr. Luisa Gomez. And now I want to invite my co-author that I thought he was not going to be able to do it, Dr. Alfredo Pla, who is a professor at the University of Minnesota at Mankato.
Yeah. Thank you. Thank you for the invitation. It is a pleasure to be part of this event. And this paper is the result of a collaboration between a lawyer interested in human rights, Andrés Molina Ochoa, and myself, who works in the field of Latin American literature. The primary purpose of this essay is to explore how narrative fiction can be understood as a mechanism to fight against impunity in the context of gross violations of human rights, as it is the case in the banana massacres of 1928. From this perspective, we believe that in specific cases like Garcia Marquez's novel Cien Años de Soledad, published in 1966, almost 40 years after the Banana Massacre, literature fulfills an important role that echoes the objectives of the Truth Commissions inside the framework of the right to the truth. Narrative fiction facilitates a collective right to know the truth about serious violations of human rights in order to prevent recurrence in the future. In the case of Cien Años de Soledad, Garcia Marquez is revitalizing the memory of the massacre to avoid its oblivion. Oblivion in this case can be understood as an example of a manufactured consent that was caused to the misinformation promoted by the government of Abadia Mendes at the time. Garcia Marquez's novel is disrupting this mechanism between impunity and oblivion with this novel. We believe that it is not an overstatement to argue that the crimes committed in 1928 in the Banana region are part of the nation's memory thanks to Garcia Marquez's novel. So this is the core of this chapter, and I'm talking about the literary perspective. So if we would like to know more about the legal perspective, we can wait a little bit to Andrés Molina's participation. Thank you so much.
Well, I invite the public to read the article to know more about legal perspective, but basically I didn't anyway, I just want to add something. The main idea that Alfredo and I had is that we can learn from the reading of Cien Años de Soledad as a way to foster, to understand, and to justify the right to the truth. Because in that sense, 100 Years of Soledad, Cien Años de Soledad is a very successful story because it contributes to remember a massacre. So maybe we should pay attention to this successful story to recover the right to the truth in the peace process. How are we going to do it, and what are the lessons? Well, those you can learn it in the article that I wrote with my good friend Alfredo Platt.
Muted, Andrés.
So now I think we can go with the QA session. I think Jennifer
Yes, I believe Jorge is going to be chairing the final Q&A session.
So thank you very much. I'm really happy we have had in the last hour or so a really succinct presentation of the key issues. Our idea was to have a bit more of engagement and questions, and I have seen there is at least 13 questions, and some people have manifested their willingness to begin. So in order of keeping justice, Professor Guardiola Rivera said he wanted to address one of the questions. I think Professor Justice Danilo has an answer, and then we will address the other question. So I think this is the best way to and I'm going to try to organize them by session as best as I can. So this is on the fly, so please bear with us. So Professor Guardiola Rivera, please.
Thank you, Jorge. You're very kind indeed. The question concerned whether these aesthetic expressions that we have been seeing in negotiations and demonstrations are unique to Colombia. And of course, the answer is no, they are not unique to Colombia. But it is the case, as the question also suggests, that there are important specificities to cases such as the Chilean case, the Colombian case, perhaps also the case of the United States, in which aesthetic means are used not as a form of therapy, but rather they are the means through which a people constructs itself as such, which is to say, it gives itself a normative orientation as well as an expression to its emotions. Emotions such as hope, emotions such as anger become present and concrete via these aesthetic means. And of course, we have seen that in the course of the current demonstrations in Colombia. These aesthetic means are not the core, rather they are of the utmost importance insofar as it is through them that subjectivities, new political subjectivities emerge, which may be the ones that are required in order for a process of redistributive justice to succeed thereafter.
Thank you so much, Professor Guardiola Rivera, for your answer. And I think it's closely connected with one question that is coming in a moment. But Justice Danilo, he asked for the word, so please.
I'm sorry, it was an accident this time, but anyway, I'd like to say something about the question related to the risks of impunity in transitional justice. I think that risk always exists, and the images of greater impunity is always wielded in transitional justice cases. But you have to look more carefully at that issue. In the Colombian case, for example, impunity, I think, is what existed before the peace agreement. Thousands of victims due to the armed conflict with the same number of processes that did not end in sentences, or that end in sentences but without the capture of those responsible. And now the main perpetrators are turning to transitional justice. They are telling the truth. They are acknowledging responsibility, and they are repairing or willing to repair the victims in exchange for more flexible sanctions. And this is the dilemma of impunity in transitional justice scenarios. Either the images of having done justice before the transition is presented when in reality is not true, or the images of being dispensing insufficient justice but with tangible benefits is presented, is what I like to say. Thank you.
Thank you very much. I have seen a couple of questions, and what I'm going to try to do now is try to connect them like in the order of answers. I'm going to ask to all panelists. We had a plan, but plans are sometimes difficult to follow. The Colombian peace process is one of them. But I would like to give like the opportunity to people that have been active in the chat. So the first question is, I'm going to try to order them in order so somebody has something to say. So Professor Elster, so it's this first question ever asked was for you, like, is that you have stated that your work on emotions are one of the elements that have to be taken into account in transitional justice. So what is the role of political emotions with regards to the Colombian Peace Agreement, in particular the referendum?
Well, can you hear me?
Yes.
Mm-hmm.
Well, obviously anger. One question that arises is whether the anger will decay. Many emotions have a short half-life. So maybe by dragging things out, the anger might become less acute and less virulent. That remains to be seen. It's not always the case, but it's sometimes the case. There's another aspect of anger that's interesting, which I know from other contexts, is that the people who were very passive prior to a transition often become the most adamant in demanding harsh punishment of wrongdoers, as if their activism after the transition could compensate for the passivity before the transition. I think I mentioned that briefly in my chapter. Now, the emotion of hope has been mentioned many times. I'm not very certain that hope has any kind of causal efficacy in inducing action. I don't think hope has an action tendency. The action tendency of anger is well known. It's we want the bad guys to be punished when we're angry. But hope is not an emotion, in my opinion, that is well defined with respect to its cognitive antecedents, that is, beliefs triggering hope, or the action tendencies that the emotion triggers. So I'm skeptical about the role of hope. Now, there are, of course, many other emotions that could enter into this situation. For instance, wrongdoers, instead of being shamed, could be shamed by various measures of ostracism. But I think anger is by far the most important emotion, I think, in these processes.
Thank you so much for your kind answer. So I just sorry, I just lost it. So the next question, I think it's directed to Professor Saffon, but in order we can ask it as well for Upribny and Dr. Upribny and Dr. Giza. I cannot read it right now, because of Zoom, something happened with my Zoom. But the question has to do with the role of popular supports, how popular support was important, and how can popular support for a peace agreement can be achieved. I guess that was the center of the question.
Okay, thank you, Jorge. So of course, popular support had an obvious role to play in the peace agreement in Colombia, because the people who agreed to it explicitly agreed to a plebiscite endorsing the peace agreement, right? But I think there was an additional reason for why this made sense. There's a lot of discussion right now whether the plebiscite should have taken place or whether it was a mistake to call for the plebiscite. But the additional reason for this to make sense was that, as I said, there were structural conditions that had to be broken for the peace agreement to hold, and for the transformations that it sought to achieve to be possible. And in a way, what the agreement tried to do, or what it was pierced, was by a profound paradox, which was that in a way, the transformations that the agreement sought to achieve required minimal preconditions that didn't exist at the moment, but whose absence was the reason why the transformations of the peace agreement were so important. I hope this is not, tricky to understand, but basically, things like political incorporation, right? So many people in Colombia don't participate politically, they're disengaged, the vote is not mandatory, poll stations are very far away, and also when people try to mobilize to participate politically, they get killed, right? And so if you want to change the balance of power at the local level, to change the violent equilibrium that I described, you need for people to start voting for change, right? But when people start voting for change, they might get killed, right? And so this is what makes the change that the peace agreement knows it's necessary so difficult. So what happened with the plebiscite was that I think negotiators hoped that the vote for peace would mobilize people enough, right? So that the balance of power would change. But in the campaign for the plebiscite, while the opponents were very efficacious in mobilizing against, there was a very heterogeneous mobilization for peace that didn't garner enough support. That didn't mean that people were not for peace. It just needed more time to build the coalition for peace. And what you see now is that people have started to mobilize for peace because the promises of the agreement are there. And so there are new political forces that are very, very strong and are trying to make their voices heard, who are now trying to make peace a reality. But I think the process of popular support building just took more time and in a way was underestimated. And of course that brings also the risk of people being killed in the process of change demands.
Yeah, thank you so much for your answer and the sad implications it entails. I think this will be also a good opportunity for Professor Upribny and Professor Giza, because it's also closely connected with the issue of legitimacy.
Thank you. Yes, it's very closely connected. What I think is that the Colombian peace process shows the complexity of the relationship between democracy and achieving peace. Peace, the idea of peace is popular in itself, but the concrete peace accords are always, in a sense, divisive. And so you have here a paradox that you need popular support in order to make peace sustainable, but at the same time, putting on vote a peace accord is risky. And the Colombian case shows that. Now, after the failure of the plebiscite, many scholars argue that it was a mistake to put on vote the peace accord. I don't agree. I think that it was a good idea because not only it makes more rational the negotiations in the table of negotiations, as Elster has argued, but also I think that the development of the peace accord, of the peace process, was impossible without this promise that at the end of the day, the citizenry would decide about the result. Always when a lot of people say that in Havana, Santos' government was making an unacceptable negotiation with the FARC, always the government say, at the end of the day, you are going to decide. And that makes the process possible. I think that the mistake was that those of us that we were on support of peace didn't recognize the difficulties for gaining popular support for the peace accord. We especially the government take it for granted, and there were a lot of mistakes made during the peace. If you want mobilization for the day of vote, I cannot tell you here, but there were a lot of mistakes. So it was a risky situation, but I think it was necessary. But of course, it was a great blow to the transformative potential of the peace accord, and we are living with that now. And I think that the challenge that we have now is to articulate the political mobilization that Colombia is living now as a means to create a new opportunity for democratic support for the peace accord. I think that's the challenge, one of the challenges in which we are now in Colombia. Thank you.
Thank you so much for your both your answers on the question. It's a bit difficult. We have only a couple of minutes, and we have an important selection of questions. So, and I don't know, I'm going to begin with those that has been assigned to certain individuals. So, to Professor Murphy, there is a technical questions on the notion of circumstances of justice and roles. So, like, perhaps one way to summarize this: our discussions of transitional justice has been excluded from the Rawlsian paradigm. What can you respond to Jorge Sanchez Perez's question? Just one thing. Let's try to be like 30 seconds, so everybody else has a. I'm sorry, just like gonna be like Jeopardy style. But okay. Let's try to be brief. Yeah.
So the short answer is that Rawlsians are too thin in their defining the context in which questions of distributive justice that Rawls is interested in come up. So I think one of the interesting insights for moral philosophers in looking at transitional contexts is it helps foreground all of the implicit assumptions that a lot of philosophers make when answering the question, what does justice demand? That's always a contextual question. And Rawlsians, the challenge is to make more explicit a lot of implicit assumptions. So that's kind of to the philosopher. Can I just real quickly, there was a question about the US and can Colombia say
Yes,
something
please.
to the
Yes,
US?
please.
And I'll
Yes.
just say a resounding yes to that. There are so many lessons for the US as we struggle to deal with our own legacies of racial injustice that can be drawn from Colombia. And I'll just underscore one of them, which is in the US, the fact of controversy is used as a way of shutting down debate. So if there's disagreement or something is controversial, that's a way not to deal with it and to silence dissent. And one of the lessons from Colombia is that the fact of disagreement, even when it's really deep, doesn't provide a reason for not engaging with or pushing for justice where it's needed. So that's one of many, many lessons I think Colombia has for the US, but short answer is yes, we have a lot to learn.
So on that point, I would like to give really briefly the opportunity to Yuri, because Yuri's paper was closely connected with the ethnic component, the Afro-Colombian component. So please, Yuri.
Thank you, Jorge. I think that both Black people in Colombia and in the US, I had the opportunity to live in the US for several years. I can tell you that we both share the legacy of slavery that has impacted our communities negatively, and also the current situation of structural racism. We both share that context. Different levels, different particularities according to the context. In Colombia, racism can be experienced different than in the US because there is colorism, there is pigmentocracy. In the US, it's more blunt. I like to say that in the US, people are more honest about their racial biases than in Colombia. In Colombia, tend to be more hidden, but it's there present in the way people interact. But with respect to the question, I would say that transitional justice, as I understand, is usually thought as a mechanism to go from certain societal situations to another, from war to peace, from dictatorship to democracy. I wouldn't jump to say like we should apply a transitional justice framework to the US, but I do think that there are some elements of transitional justice that can be used to address the racial disparity in the US. And I mean like adopting policies that can try to, with the specific goals to address the inequality or the racial inequality existing in the US. That when we reach to a certain point of material or real equality, maybe that policy might not be necessary. But in the meantime, we need to adopt certain measures that can address that reality, that deep inequality that exists not only in the US, but also in Colombia, that I think is even deeper in Colombia, the racial inequality. There was another question I will briefly, if you allow me, Jorge, to answer, which was with respect to whether the peace agreement deals, or how does it deal with gender and LGBTI rights?
Yes, please.
Yes, the answer is yes. The peace agreement basically contains three differentiated approach. One is a territorial differentiated approach by which it tries to prioritize regions or municipalities disproportionately impacted by the armed conflict, and to provide resources to invest and to improve the situation or the condition of life of people inhabiting in those areas. Another one is the ethnically differentiated approach, which tries to ensure that the ethnically aspect is taken into consideration in the implementation of the peace agreement. And there is another one, which is the gender approach, which tries to guarantee that gender issues are taken into consideration in the implementation of the peace agreement and in the work of the institutions in charge of implementing these agreements. Thank you.
Thank you so much, Yuri. And in the interest, we have a couple of questions, and in the interest of time, I don't know if we can continue for a bit, just take a couple of minutes more. And I try to organize them in a way that they flow. Let's try to be really brief and precise in the answer. So I think a couple of questions deal with the issue of drugs, which is one of the sources of conflict, and transitional justice, whether the Colombian system will deal with the drugs issue and whether that can be implemented to another countries like Mexico. I'm connecting two questions. So will anybody of our transitional experts want to mention something about this point? Transitional justice experts. Yeah, but just very briefly. So I think, Danilo, yes.
I just want to say that, like many other common crimes, the crime of drug trafficking can be tried by the SJP if they are related to the conflict. And in the examination made of the subject by the Colombian Constitutional Court, it found that it does not violate either the Colombian Constitution or international humanitarian law.
Yep. Thank you so much. And the other question is are concerning with the agreements between well, the appropriateness of the sanctions of HEP, and also whether they accord with international criminal law. So this question was for Professor McCoy, if she, well, and Danilo, but I think Professor McCoy has to leave. Just so the question is whether is Colombia the new standard for international criminal courts, international punishments.
Oh, sorry, I'll just come back really quickly. I was just about to leave.
So sorry about that.
Yes, I do think that it provides a new standard by presenting, particularly on the alternative sentencing, because the effective sentencing question is what had been raised by the head of the ICC. Their questions about whether the relatively short sentences would meet the proportionate standard. And, you know, as long as the responses and sentencing are accepted and stand, you know, then that would set a new standard in terms of filling in some of the gaps, I think.
Thank you so much for returning for that. And I think I'm going just to connect. Unfortunately, we cannot deal with them, and in the interest of time, the last two questions are directed towards, I think, Claudia and Alfredo. And Claudia, it's the connection between education reform and land reform. Are there any connections between them, particularly if whether land reform is possible? I think that's the point. Without education reform, and also the connection between education and memory. And then we make to Alfredo, because is there a policy to teach this? I guess that to teach conflicts in Colombia.
Okay, so short answer: real education reform is not necessary or sufficient for land reform, but it can certainly help, and it can help in two ways. So one way is if you focus on citizenship education and you help people understand the rights they have, it is more likely that they will push for reforms that involved also land reform. And second, if you focus on skills, it would facilitate them to not only things like making land more productive or that sort of things, but also different forms of organization economically to like cooperatives and things like that to work on the land. So that would be like my two things. And then regarding memory, in the peace agreement per se, it was a point regarding the keeping memory, not exactly how to teach it. And that faced the issue of having autonomous schools in the country. So what did the ministry is to set up like a sort of guidelines, which actually were somewhat of menu that the schools could just choose to, and memory was one of them. But that doesn't mean that the schools have done it or know how to do it. And even very often when teachers attempt to do that, they are put under the spotlight by parents or community or everything, which makes it very difficult. I will just leave it like that.
So, thank you, Claudia. Alfredo, if you have something.
Yes, the case in Colombia is interesting because the constitution of the literary canon goes beyond the institutionalization of policies around education. But one interesting fact is that the two most important novels of the 20th century talks about violations of human rights. One is La Vorágine of José Eustacio Rivera, 1920, published in 1922. And the other is 100 Years of Solitude. So the arts and literature and painters and they have an important power to communicate atrocious moments of the history of Colombia that in many cases has been deleted from the nation state. So yes, literature is always an alternative to recover serious violations of human rights in the history, not only in Colombia, but in Latin America. We can build a canon around these situations in Latin America very easily, because these cases repeat in Colombia, Ecuador, Peru, Chile, Argentina, Uruguay, almost in every country. So yes, there is an important function, not always related to specific policies, but how the constitution of the canon and the constitution of literary prestige works in these countries for different channels. Yes.
So Anna, just before concluding and in the abuse of time, I think like most of us has the chance to address one question, and there is one about civil society, and perhaps the more was directed towards Dr. Gallón and the Colombian Commissions of Jurists. What is the role of civil society and civil society organizations in implementing peace? And just to add, like everybody else who can support and do something for the peace process. With this, I think this is the last question, and I think we have addressed them all.
Thank you, Jorge. I think the role of the civil society is enormous, and I think the civil society is going to be decisive in resolving this conflict between partisans of the peace agreement and people against the peace agreement. I think many sectors or important sectors of the civil society are not or were not aware of the really content of the peace agreement at the time of the referendum, and I think that they can change their views about it. Most of them have changed their views about it, and most of them are going to change their assessment of the agreement according to the results of the institutions created by the agreement. Once the justice, the jurisdiction for peace, and especially the jurisdiction for peace is going to take decisions on several cases, most people are going to see the importance of the agreement. Of course, many others are going to be against those decisions, but I think that most of the people are going to appreciate the importance of these decisions, as well as the report of the Truth Commission and on the achievements of the unit for the search of disappeared people. In conclusion, I think that it is very important to make many activities in order to show the different sectors of civil society what the agreement is, what the results of the agreement are, and what are the benefits for the Colombian society about this. I think this was one of the failures before the referendum. The lack of dissemination of the content of the agreement and of the importance of that, and it prevailed a distortion on the interpretation of this agreement. Thank you.
So just before, I want to thank everybody just for staying here until the end, for having time and patience for addressing the question. I don't have anything more to say, so I pass it to Nancy or Andrés if they have something to say, and then to Jennifer, who is our official.
Muchas gracias a todos, and thank you, and I hope to meet you again. And if we indeed continue, and I'm sure the path will continue, the question is who will be on it. And in spirit, of course, we're on it. So I look forward to welcoming people to McMaster again, but perhaps there will be another voice that says hello. Thank you.
I just want to say thank you to everybody, and especially to Nancy and Jorge, because they make this possible. And again, I hope this continue, because this is something that we must continue researching, and I hope we can meet again to speak and to learn more from each other. Thank you again to everybody.
Thank you, everyone. And the recording of this event will be made available shortly on the YouTube page for the Center for Human Rights and Restorative Justice. Thank you.
Thank you. Thank you, Jorge. Bye. Bye,
Thank
Nancy.
you all.
Bye.
Thanks.
Thank you to all. Thank you for everything, for having this event and having us. Thank you.